The Supreme Court now has issued a notice to the centre over a petition seeking criminal trial of a juvenile convict in the December 16 Delhi gang rape case. Remember, her parents in fact had moved the Supreme Court and they were in fact demanding a criminal trial of this juvenile convict in this entire case. Earlier, the juvenile court had trialed him, in fact sentenced him to 3 years of punishment. Remember, that is the maximum that a juvenile in fact can get under that law, after which the parents were extremely disturbed. They decided to move the apex court. Now what we're getting to hear, the Supreme Court has issued a notice to the centre over this petition seeking criminal trial of the juvenile convict. Meenakshi is now on the phone line. Meenakshi, take us to what really has the court said today.
Well, yes, absolutely. The Supreme Court has, you'll recall, in the backdrop of Nirbhaya's parents having moved Supreme Court, they were challenging the provisions of the Juvenile Justice Board. Essentially, it was obviously pertaining to the trial of the 17-year-old accused. They were demanding fresh trial by a criminal court similar to the one where the 4 other accused were found guilty. The parents had made the Union of India a party, and essentially today the Supreme Court has sought responses from the government on this aspect of law, whether or not the magistrate will have the power or authority to decide harsher punishment for the juveniles who have been charged with heinous crimes.
Now, Meenakshi, earlier we've seen a PIL which was moved to ask for an amendment in the juvenile justice law, which was not entertained by the Supreme Court. But obviously we are getting to hear that the cabinet in fact is also mulling now to move a note to amend this entire law, keeping in mind the kind of crimes that these juveniles commit. Now, any observations coming in from the Supreme Court at this moment?
Today was the preliminary hearing. You're absolutely right in pointing out that on an earlier occasion it was Dr. Subramaniam Swamy's plea in the Supreme Court which had not found favor after long deliberations. So yes, you rightly pointed out that point in time the court did not feel it appropriate to really revamp the entire act, given the fact that there was one instance of this particular case, the Nirbhaya case. In that backdrop, Dr. Subramaniam Swamy had approached the Supreme Court. At that point in time, the Supreme Court, after hearing arguments, had gone ahead and dismissed it. However, now, today, again, the Supreme Court is willing to hear in-depth arguments on the point of law, whether or not the magistrate who will be the authority deciding the juvenile accused cases, whether or not the magistrate should be vested with powers to go ahead and really look in depth at cases where the juvenile is accused of heinous crimes, and whether or not in that scenario the magistrate will have the authority to proceed with harsher provisions of law if at all the juvenile is found accused of heinous crimes. What makes this petition very interesting, Deepthi, is the fact that it has been filed by Nirbhaya's parents, and this particular plea says that the imposition of a blanket ban through the Juvenile Justice Act on jurisdiction of criminal courts to try a juvenile accused of heinous crime of rape and murder was unconstitutional, and it has obviously sought a direction from the apex court to strike it down. How it will proceed is worthwhile to watch. Today was the first hearing when the court was of the opinion that it is willing to hear lengthy deliberations further on this particular aspect of law.